This conference will now be recorded.
Okay. Good morning. My name is Mary Ann Cody, and I am the chair of this commission, and I would like to now call the meeting to order. I ask the town clerk to please take the roll.
Chair Cody,
Present.
Vice Chair Hendon,
Present.
Member Bingham,
Here.
Member Cassidy,
Present.
Member Sloat.
Here.
Thank you. Would you please join me in standing for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I would now like to entertain a motion for the minutes that were included in your package from the November 17th meeting.
I move to accept the minutes as written.
All right, second?
Second.
Is there any discussion, correction, comments, or additions? Do you have? All right, that being said, may we have a vote? All those in favor, show of hands. Aye. The minutes pass. Thank you. The proceedings are now called to order on agenda item number 2, quasi judicial hearing to consider the variance request for 6161 North Ocean Boulevard. How's that?
An application submitted by Erica Sneed as agent for Rosalind and Stanley Middleman for a parcel of property located at 6161 North Ocean Boulevard, Ocean Ridge, Florida 33435, requesting a variance from the provisions of Land Development Code, Chapter 67, Building and Building Regulations, Article 2, Coastal Construction, Section 67-18, Coastal Construction Setback Line, also from the provisions of Land Development Code, Chapter 64, Zoning, Article 3, Supplemental Regulations, Section 64-41, accessory uses, buildings, and structures generally to permit a chicky hut that would be located east of the 1979 Coastal Construction Control Line and would encroach into the site setback for accessory structures. The variance would allow for 210 with 63 feet setback from the 1979 Coastal Construction Control Line and a relief of 8 feet and a required 15 feet setback. The property is located at 6161 North Ocean Boulevard. Property control numbers 46, 43, 45, 27, 08, 003, 0030.
Thank you. At this time, any ex parte communications should either be disclosed by identifying the subject of the communication and the identity of the person, group, or entity with whom the communication took place, or any correspondence be provided to the town clerk and made a part of the public record. In addition, each member of the town commission may identify the existence of any investigations or site visits he or she has conducted or any expert opinions received, and disclose any conflicts of interest on this matter. Now, I would ask each member to disclose if there is nothing.
I went up on the ocean and took a look at the site where this is planned and where the platform is.
From the ocean side.
From the, so I could get an overall view.
Well, I admire your diligence in walking out there.
I visited the site via Google Earth.
I called Erica Sneed on Friday night and asked if I could go up over the weekend to take a look from the beach. And on Saturday, and she said that would be fine. So on Saturday afternoon, I went up steps from the beach to look at the site.
And I made no effort to walk down that far. Sorry. We will then proceed with the hearing on this matter. Will the town clerk please swear in the witnesses?
Okay, so anyone wishing to speak on this item, please stand up. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? When you come forward, please state your name and address clearly for the record and whether or not you have been sworn in, and please speak directly into the microphone.
Thank you. The town staff will now make its presentation on this matter.
Good morning, Chair, board members, Corey O'Gorman, town planner. As the town clerk indicated, this is a request for a variance from the coastal construction control line and the side setback line for a cheeky hut in the rear yard of the subject property. The staff report outlines background on the request, provides analysis of the two requests based on the criteria in the code. The application itself also provides background on the application as well as their analysis of compliance with the criteria. One correction to point out, and that is that the 210.63 feet is actually measured from I think it's the 1997 coastal construction line. So the request is actually for 31 feet from the 1979 coastal construction line. The staff recommendation is to consider the staff report, the application, testimony you will receive at today's meeting, and make a decision on the application. The report also includes several possible conditions if the board decides that we would like to approve the application. We're here to answer any questions that we can. Thank you very much.
Thank you. Are there any questions? Is there another next witness?
Thank you, Durante Guy, building official.
Thank you.
There's really nothing to add from the presentation that we have here. Just to say that this came up during a routine inspection of a application for a wooden deck and stairs. At the time of inspection of the wooden deck and stairs, it was noted that there was a horizontal structure that was being installed. And we were advised that the horizontal structures for a cheeky hut, which does not require a building permit per state law. However, the location was within the normal 15-foot setback, which is why that was pointed out. And one of the reasons why that permit did not get approved for the state that it had requested an inspection. Thank you.
Any questions? All right. Any more on the town's presentation, or is that it? Okay, thank you, gentlemen. The applicant will now make its presentation on this matter.
Good morning. I'm Erica Sneed, and I am here. Can everybody hear me? I don't know.
Yes.
Okay. I'm here representing on behalf of the homeowners. I'm actually the contractor that was hired in order to perform the work on premise. And, you know, we are basically requesting for the variance, you know, for this structure based on how our homeowners have gone through a major reconstruction in their backyard with the seawall construction, stair construction, and then a wood deck that had also been, you know, constructed as well. So we were looking to install a cheeky hut over the wood deck that had been, you know, permitted, it had been approved. It had been approved by the state with the DEP, and we were looking to provide, you know, a shade structure over that particular footprint. Unfortunately, based on the setbacks for that particular lot, you know, we do have to utilize 8 feet of the normal zoning setback and regulations. Other than that, the structure itself is completely regulated, it's approved. There's nothing wrong as far as the building and the construction, since it's all natural materials and so forth, but it's just a matter of being able to utilize that additional 8 feet to have the structure, you know, approved by your codes and your ordinances. So we're here today just to, you know, try to get that pushed through, since the rest of the project has been approved and has been permitted. So if anybody has any questions that you would like to ask me or address, I'd be more than happy. So.
the seawall and the deck
Mhm.
are in compliance with the setback rules.
Yes.
Was the contractor not aware of the fact that if you put a structure on top of it, you would need a 15-foot setback? And therefore, they would have to locate the deck further away from the property line?
We had received the approval by FDEP in relation to the structure. So with that being a part of the original permit, we didn't foresee that the structure itself would be, it would be an issue since the footprint of the deck had already been approved. So that's why we went ahead and we proceeded as normal.
But the contractor should have known that there's a difference between what FDEP can authorize and what the rules and regulations of Ocean Ridge are. And who we would have to go to get permission to build it within the setback line.
Yes, and I am aware, of that, but we've gone off of, basically the entire project itself, the fact that it already gone through, the approvals and the permit, and that this was the logical, location for the structure to be built since it was meant for a shade structure to cover the deck, which had been approved.
That means anytime someone builds a platform, they can build a shade structure closer to the property line, which will do away with basically the ordinance of the 18-foot setback, but the privacy of the neighbors.
Well, no, I wouldn't say that that's necessarily the case. I think we were basically going off of, again, the fact that it had been approved by, the FDEP, which, typically is, one of the biggest, sort of, I don't want to say it's a red flag, but it's typically, if they have signed off on, construction for a project, then, we would, unfortunately, we kind of, well, I don't want to say an assumption, but since they had approved the structure, in the location of where that deck had been placed, we didn't see that that would be an issue with proceeding with the structure being built.
My point being, if they'd gone through all the rules and regulations, they might have relocated the platform, deck, whichever, a little bit differently so they could build the shade over the top of it. I have a feeling that the deck is where it is, and keeping it so they have a clear view of the ocean. If this continues, what happens to other people's clear view? This structure is 20 feet tall.
No, it is not. I believe 13 feet is the height of the structure.
Not 20 feet.
No, it's not 20 feet tall.
Is that better than a story? One story.
About one story. The peak of the top peak of the structure would be about 13 feet, and then it slopes down on the
I
sides.
think, I'm sorry, I misspoke, but I think we're roughly 2 stories.
No, it's less
Can I
than.
ask a question? How did neighboring properties get their chicky huts approved? Because there is, I believe 2 properties to the north. There's a chicky hut that is right on the edge of the property. I'm just curious how that.
It's good.
Yeah, to the
To
town,
town.
you're asking.
Yeah.
Can you answer that, Mr. Guy?
Since I've been here for 2 years, we have not had a zoning request for a location of a chicky hut. What we have observed is that there were some that were in place prior to me being here. And the truth is we have not done research as to whether they had been given zoning approval or not. So I couldn't speak to if
Because I think there are two between 6161 and Edith Street.
Again, I have not researched these.
And
I
they're right
have
on
not
the
looked at the setback to say whether they are or are not in the proper setback or if they were given zoning approval.
Yeah, and I mean, we have always in the past done for Cheeky Huts zoning approval. That's why we have a no fee zoning process for this, that it's a no fee. So we have a process in place for this specifically. Now, specifically to those addresses, I don't know the history of when they were installed to know exactly.
Well, they were rebuilt after the.
Well,
seawall.
things that were there before can be rebuilt. We allowed them to be rebuilt because they were technically grandfathered and you can rebuild anything.
Like the deck.
anything that was previously there, because it's a natural occurrence and it wasn't them willingly, voluntarily taking it out. So they could have rebuilt it, but I don't know exactly when it was approved, but we might have had that in place.
That was my question.
Well, if I may step in, I mean, in reference to that comment, I am aware that there are, structures that are definitely not within the compliance and the setbacks in Ocean Ridge. One is to the property to the north, which I know obviously that falls under the grandfather portion, but we were responsible for the construction of that tiki or cheeky hut when their seawall was reconstructed and they had their deck that was reconstructed. And then there are about, I would say, 8 or 9 houses south on Ocean Ridge. There is definitely a cheeky hut that there has been no permit that was ever approved. There's no DEP permit. There is nothing on record for that particular structure. And that is well within, the encroachment of a 15-foot setback on that premise. So I don't know what the rules or the regulations were for that structure to have gone in, but that would be no different. And here we are, stating everything in front of you all and trying to get this approval when that's plain as day. And it's a much larger structure than what we're trying to construct as well.
We have to be really careful about comparing things. Things could have been constructed under different codes in different years. Codes evolved throughout the years, so we have to be really careful about not comparing.
And Madam Chair, for every variance that comes before you, it's on a case-by-case basis specific to that property. So while there may be other issues at other properties that, the town may need to look at for code enforcement purposes or community standards purposes, your consideration today is just this property and the variance that they're seeking.
So noted, thank you. Are there any other questions?
I have a question, Ms.
Yes.
In justification of your variance, you put the literal interpretation that provisions of the ordinance would deprive the applicant of their rights. What other interpretation can you have?
That it would deprive, I guess I don't really know as to if you want to rephrase, or I'm not sure as far as the clarification. It comes down to, the fact that they, that's the location of where their deck has been, permitted. That's just the spot on premise, since it has the stair access and so forth. That is, the proper location for the structure to go. And it just seems that it would be, but now we know that we can't, use other structures in reference to, because it's a case-by-case basis. So I guess in other words, it's just a matter of, this is where the deck is, this is where the shade structure is desired. This makes the most sense as far as the property is concerned, as far as the layout and access to the beach and the stairs and the seawall. This is the proper location of where the cheeky hut should go.
Thank you.
Just a point about the literal interpretation of the code. When the homeowner bought their home in 2018, the setback, the east setback, was not the coastal construction control line. That was put in place by the commission through an ordinance in September of 2020, and I believe the intent of that ordinance was to protect the dune. But Ken Khalil, former commissioner and mayor, who got up to speak at the May 3rd meeting in 2021, pointed out that this could have unintended consequences. By using the coastal construction control line as your setback, you're imposing a hardship on the homeowners who want to do anything with their property east of that line. And he warned of that, and the commission voted to not put it back before the planning and zoning. But I would just point out that this is an exact example of what he was warning against.
I disagree, because this is not a setback from the ocean. This is a setback from the sideline. So
No,
you're
there are two
infringing upon the
pieces to it,
privacy
Betty.
of the reason we have setback is to keep privacy for the neighbors. Otherwise, I can, if I build a platform, then I can build whatever I
I'm
want.
not talking about the side setback. I'm talking about the setback from the ocean, that the commission voted to use the CCCL line which basically goes, I don't know if it goes through the house, it goes through properties that are along the ocean.
That's right, and the commission traditionally has allowed variance from the setback of the coastal control line. But that has no bearing on whether it is set back properly from the property line.
Yeah, no, I wasn't talking about this, I was just talking about the CCCL line.
Well, but we're talking about where the tiki hut can go.
Right.
And if, when they built the whole thing, if they were thinking about a tiki hut, they should have moved their platform 8 feet further away from the property line.
But they already had the permit in place to do the deck, so I'm just saying, I sympathize with the misunderstanding. Because the chicky huts are not, you don't have to have Florida, building approval, DEP approval.
Don't the Indians consider a tiki hut a cover?
It's a shade structure, yeah.
Any other questions for Ms. Sneed? All right, do we have any other? Thank you, Ms. Sneed. And I didn't know if there's any other people speaking on behalf of the applicants. Are the homeowners interested in speaking?
Well, first of all, thank you for considering our application. And we certainly didn't want to take up your time. We didn't expect there was a variance required. We got the approvals for the deck and we intended to add the structure later for shade or not. We didn't really know. We wanted to see how it looked. And then we saw how nice it looked at our neighbor's house next door as they completed theirs and decided that we would go ahead and get one too. And we understood at the time that we didn't require approval because of the state ordinance for the Cheeky Hut. So our only hope is to get a little shade over our deck that we had already gotten approved. It was not to take up your time or to waste everybody's energy around this. We thought it was a fairly simple matter. Of course, 9 months later, probably not as simple as we thought or expected, or a lot of money later as well. So we would appreciate it if you would just help us move on with our lives and get a little shade over our deck.
Thank you, Mr. Middleman. Any questions? No? Any other speakers on behalf of the applicant? All right. At this time, any other member of the public who wishes to submit relevant information to the Town Commission may come forward and speak for a maximum of 3 minutes each. Please indicate whether you are for or against the project, or neither for nor against the project. All right, I'm assuming there's no other additional public comment with regards to this application. So now I will allow the staff to make final comments if they would like.
Chair, board members, we have no additional comments.
The applicant may make any final comments if they would like. Do any members of this board have questions for the staff, the applicant, or anyone else who has spoken on this, which is no one?
I have further questions on the other tiki huts. The other tiki huts were never authorized. They were built without any permits, which frequently happens in the town.
I don't want to say that. Again, we would have to do the history on it. I'm just saying that in the past, we have no fee zoning application in place for Cheeky Hut specifically because of their exemption from the Florida building.
So how does that affect this situation, the no fee zoning?
I mean, after,
Can you just
if the
explain?
board approves, then they go for a no fee application to install the Cheeky Hut in that location. So that's the only process. There's no fee to it. We don't charge the applicant for it. So that's why we call it a no fee zoning application.
I have one final question. Are the other tiki huts within the setback line, or are they?
We don't have that information in front of us, so it will be really hard for us to give you a proper answer. That would require research as far as staff goes. In the future, if any of you have any research questions, please let us know prior to the meeting. That way we can come prepared.
I have a question.
Please, I'm sorry.
I have a question of the Middlemans. So your interest is strictly for shade for your deck? Any plans for shower from the beach, summer kitchens, grills? Pardon? Already there elsewhere on the property, not within the.
No, they're not in the, not in the.
Not anywhere near it.
Thank you.
I think that it's understandable, the confusion though, if they had approval for the deck, I'm just, trying to look at all sides here, and they see what their neighbors have done, that it seems, I don't know, like onerous on them to assume that they're going to go and look in the code and find that a chicky hut is an accessory structure, therefore it needs to have a variance.
That's why I blamed it on the contractor. The contractor should have known. That's why he has a license. We would still have a restaurant if it said, well, if it was there, we wouldn't destroy it.
So I have a question in furtherance of Bruce's question, which was, there will be no additional improvements made to the Cheeky Hut, including electrical, mechanical, gas, plumbing,
No,
nothing, and no effort to ever enclose it?
no.
Just shade.
Just shade.
for shade.
It's a question I had to ask. Thank you. Any more questions for either side? All right. I will now declare the quasi judicial hearing closed. And we will now proceed with comments and deliberation by the board. Let's start with Mr. Sloat, if you have any comments.
Well, I think the motion to approve would be conditioned upon the fact that the applicant say no additions will be made at this time or in the future to that Cheeky Hut. And I think that's a very relevant issue. That's it.
Thank you. Betty, do you have any?
I believe I've stated all my feelings. So,
Yeah, we've been an appropriate amount of time. Yeah.
What bothers me is if we continually allow people to infringe upon setbacks, and then because of people's propensity to use that to do something else before the town finds out about it, we begin to break our codes down. And if we want to have codes, we need to adhere to them.
Point well taken.
Well, my feeling is with all due respect, Betty, the platform was approved. The platform is actually what's in the setback, but allows the homeowners access to the beach. Just hear me out. This does not change any of the setbacks that the existing platform isn't already encumbered upon. To your point, the CCL lines, whether they're arbitrary or mandatory, was probably determined before this meeting here today by the board. So my feelings is to allow the homeowners the shade on their existing deck, which was previously permitted and approved. But I would bow to the town's recommendations that no additional improvements are made, the Tiki Hut cannot be enclosed. The one concern I have is that the variance will cease if the single family structure is demolished or if the deck is demolished, which I agree with, but then, this is adjacent to the beach. Short of the single family home being demolished, they already had to rebuild a seawall and their deck because of adverse weather events. How about the tiki hut itself? What if it is exposed to extreme weather conditions? We obviously wanted it to remain within repair, but how far does that go? That's an unanswered question. So, but my druthers are to allow the homeowners their shade.
The setback for the deck is different from the setback from the structure.
Yeah,
The setback for the deck is only 8 feet, I think. Is it 8 feet or 7 feet?
5 feet. Unenclosed decks are 5 feet.
But the setback for a structure is 15 feet. And therein is where I think the contractor should have known the difference.
understood.
I wholeheartedly agree with Bob and his concern about it not being enclosed and not adding any plumbing or electrical, gas, anything of that nature. So I agree with the conditions that this is a reasonable request.
Thank you. I also think it's a reasonable request, but am mindful of the qualifications that the town would like imposed if we do grant such a request, which is that we wouldn't have no additional improvements to the tiki hut and that it would never be enclosed. That being said, I would now entertain a motion.
Madam Chair, if I may, just real quick, as to the comment about, so let's say there's a hurricane and the tiki hut gets destroyed and the deck gets destroyed. In the town's recommendation for conditions, you could clarify, because the town's recommendation is essentially 4 recommendations. That approval is subject to the issue of a DEP permit, which I believe you already have. So that's been met. The tiki hut can never be enclosed. No additional improvements such as electrical, mechanical, gas, plumbing, et cetera, can be made to the tiki hut. And then the final one, the variance will cease if the single family structure is demolished or if the deck is demolished. If you want all of those conditions, you could clarify on that last one that unless it's an act of God. So meaning, in other words, if a hurricane comes along, it takes out the single family home, takes out the deck or the tiki hut, the variance could remain in place. But if they take an active step to take down the single family home or demolish the deck and the tiki hut, that the variance goes away and they would have to come back in unless they otherwise comply with the zoning code.
Okay, perfect.
I would agree to that. So we would qualify that, except in the case of an act of God. Yeah, okay. So I would like to entertain a motion. Does somebody want to set one forth, or shall I? I move that we allow the tiki hut at, let me see, 6160 to remain as presented in the application, subject to the approval of the permit or exemption letter from the FDEP, which has been granted. Also to the fact that the tiki hut can never be enclosed, no additional improvements can be made, and the variance will cease if the single family structure is demolished or if the deck is demolished other than caused by an act of God.
I second.
All right. Shall we take the vote?
Aye.
Eddie?
No.
No. Bruce?
Aye.
Carolyn?
Aye.
Aye. So it is passes 4-1. Should I have had the clerk call the roll, or was it okay that I did it?
It's fine.
I kind of took over, I'm sorry.
Okay. I was still writing the minutes, so I'm like, you know.
I got a little aggressive.
It's not like you, Mary.
Motion passes subject to the qualifications set forth. Thank you.
Can we get the rest of us?
Now, there's other matters before the board. You may.
Okay, we can go.
Yeah, you can go. Thank you for coming.
Thank you.
Let's hope there's no act of God. Are there any other matters to come before this commission at this time for public comment?
Yes.
Yes. And you'll be limited to 3 minutes. Is that all right?
Good morning, esteemed body. Thank you for seeing us again. We're here this morning to just go back last session where our variance was approved for the shade structure
November 17th.
on November 17th. And at the time, the request for the variance was that the setback issue was for the 2 posts on our shade structure. And when we had put in all the engineering drawings and everything that explained how it was going to be built, the only mention that we had to comply to was the 2 posts for the setback from the canal. And our house has this little wooden 3-foot balcony. It's kind of like a mock upstairs. And when they were going to mount it to the house, so they would mount the one beam directly to the wall of the house, the other beam directly to the wall of the house, and the other beam is wrapped around the balcony, and it was right there in the drawings, and there's no posts or anything there. So, but the engineer said, this is dingy wood. You got to firm it up with the trusses and the roof. So that part of the balcony was in the engineering drawings. And then when we went in, subsequently to put in the permit to build it, it was brought to our attention kind of like we were trying to pull the wool over the eyes of the city, which wasn't appropriate, saying that we never told anybody that the balcony was going to be fortified and strong or anything. And we said, wait a minute, that was all inside the drawing, and that was never part of the setback of the variance. It wasn't like we were withholding it from anybody. It was right there in view in the drawings to see it. And now we've been told that we have to go get a whole nother variance again for that balcony that was already in the drawings and already approved. And the only thing that we're doing in the balcony is, we got pictures of it, we're showing the little tiny wooden dinky one being fortified so it's strong enough to hold the weight of the shade structure. So we'll do the whole variance thing again, but it was already in the drawings and already approved. I'm sorry, you go.
No, that's pretty much the whole story. And quite frankly, do we want to go through this whole variance again?
So how did this all come?
We applied for the permits and we're being told that they're not going to provide us with the permit.
So Durrani, what's your
Okay.
assessment?
So the deck is being demolished and expanded.
The balcony.
Balcony?
Yeah, but it's a little
So the
3-footer.
second floor deck, which is 36 inches wide, that's what's existing. They're removing it, putting a new one in.
We
and
did
making
not
it-
remove anything. I'm sorry, we removed the rotting 2x4s. That's what we removed. And then we enforced it on the wood trusses that were coming out of the house.
Is the size going to be changed?
Yes, sir. It gets expanded from about 3 foot. It gets expanded by about 18 inches.
That's
But
exactly.
because of the 2x12s that they had to put into the wall, into the truss of the house, they were the old ones.
They were weathering.
The old ones were about this
25 years
big.
old.
They were literally about this big, and now they're about this big. So they were strong enough to actually have a balcony that would, so here's the sliding glass door. If you stand on the balcony is literally this big. It's just like a mock, okay? So now it's about,
It's cantilevered off the house, right?
yes, there's no post or nothing like that. It's up in the air, and you don't even see it because the shade structure that's already been approved is wrapped all around it. So you don't even see it.
You know, I can appreciate what you're saying, but I don't know what we can do because you don't have a formal application in front of us. So I don't think we as a body have any authority to.
It's not like you're
Okay.
seeking a variance. Is it a variance they need to have, or they need a permit to do what they're doing? Is that the issue?
Yeah.
They're gonna need a variance if they want to extend
So
from the
we are
3 feet.
in,
Because it's in the setback.
Yes.
It's
So,
not
The
within
balcony is
the
not in the
setback.
setback.
No,
Well,
it's
right
right
now,
to the ground.
as it was built, no. As it was built with the 3 feet, it was not. If they want to extend it,
Excuse me,
It is.
We're going to let Mr. Guy explain where we are with the situation. Thank you.
The permit is currently in plan review stage. During plan review, we have realized, and this happened during the review, that I don't know if it has been done, but according to the plans, which is supposed to be a proposal, it is proposed that the existing 3-foot deck, second floor deck, would be demolished and extended. This extension will actually be extending within the 25-foot setback. 1. 2, our codes allow for a maximum 25 square foot to extend within the setback. This is not according to the original design of the house. According to what was permitted, they would be okay with demolishing the existing deck if there's an issue of rot or structural degradation, and replace the dock or say. That is not what is happening. So they're expanding it.
So can I ask you a question, Mr. Guy? You had all of these plans when we submitted the variance. Why didn't you look at it then?
The answer to that is that once we look at a building permit, the type of review that happens for a building permit is not the type of review that happens for a application for variance or development plan review. What we look at is cursory and only for what is in that application. So when we're looking at a building permit, that is when I pull the historical files. That is when I actually look for exact measurements, and that is when I look for any deviations from what the application is asking for. So that is why we have noticed it. It's a building plan review. I mean, it's simple. They could basically just retract the and make it what it was permitted for eventually. Or if they wanted to expand it, there are other courses, but according to what I'm reviewing, there is a change to a balcony that was never applied for.
Yes, agreed. That what this gentleman just said is absolutely correct, but we didn't realize that that was something that we had to do in the variance, because if you recall, when we did originally the shade structure, Mr. Guy had come by on the 4th of July and red tagged us and told us to take it down immediately. So we spent thousands of dollars to take the thing down, right? Now, then when we did the variance, what we showed is, hey, when the house was built, we got a whole backyard is 25 feet, okay? But like 22 feet of it or something is setback. So our entire backyard really is only 3 foot. So we only have a 3-foot backyard, even though we have a 25-foot that goes on that. And when the house was originally built way back then, that little fake balcony stuck out to 3 feet. Okay, so because it was, so now when we go in to get the variance, the 2 posts that are out here, out by the canal, that was the stuff that was on the ground that we had to get the variance for the exception. Way back here at the structure is going to be built up on the house, 12 feet off the ground, okay? The little balcony thing wasn't strong enough for them to wrap the beams around it. So what they did was they said, okay, the trusses have got to be fortified. You got to put in 2x12 planks and all this kind of stuff so they can mount the beams to it. So it wasn't like we tried to hide that from anybody. It was right there in the drawings when we put the thing in, and that's it.
And the engineering.
It was all there.
Yes.
I understand, but we're not permitting. We're Board of Adjustment.
Yes, sir.
You know, just hearing this, if it's all, the balcony sounds like it's non-functional.
The one that we have, yeah.
Right. Just take it off. Why don't you just take it off and attach your shade? You want shade, just attach a shade structure to the house all the way across.
It's a hazard. A child could go open the sliding glass doors and fall
Okay,
out.
well, that's up to you.
Yeah.
That's up to you. But if you change the structure of your house, you have to go through a permit.
Okay, exactly. And basically the reason that we're in front of you this morning, sorry, I'm turning the dial back to 0, so there's no motion, is because in the process of doing the permit, this has been brought to our attention that now what we have to do is now file another variance to explain why we have to do the balcony. Because when we took the thing down, it was already built around the thing. All right, so now, and I don't even want to tell you with the price of commodities, the material's gone up 200% and everything else.
No doubt.
It's crazy, it's crazy. So it's built around the balcony, and now we have to go in and get, so I guess we have to get in the variance?
Well, I have a question for our council. Is there a abbreviated process allowed for us to go back and look at the variance and see if,
So
It
I
could be
believe that's what
expanded.
Mr. Guy is talking about, is we review the application and we look at the application. So what's stated on the application is what staff reviews in terms of preparing for this board. The application doesn't mention other variances that would ultimately be needed in order to get your building permit. That's, how these types of things happen. So there's not an abbreviated process in the code. They would have to apply for a new variance.
they couldn't file an amended
That's what
application?
I asked.
They could file an amended application, but I don't think we have any process that would allow for that to be treated under the existing process.
I have a question. What we looked at, I didn't bring the file with me, but
I
in
just have
November, what we looked at, did it show that it was going to be bigger than the existing 3 feet?
It was absolutely in the drawings,
And,
yes.
and when we get an application, like, does Durrani look at all the information that we get?
That's what he's saying. It's a different standard of review because it's
Yeah.
much more technical review for him when it's building permits. Because he's got to make sure everything complies with Florida Building Code and the technical requirements of the town's code. So when you get an application, you just look at what the application is.
Now, this is, and I have, if you can see on the screen, this is what we had received, which was in reference to the sun trellis.
Yep.
And that's the site plan. So, there is mention of the limit of the second story balcony,
Yeah.
but there's no mention of and I think staff was under the impression that it was just going to continue with the existing and not that this was going to extend, even though they did leave the space for it, but we didn't think it would be to extend that balcony.
Is the extension from the dotted line?
Well,
Yeah, this is
see,
where it is.
if you, inside the file, if you can continue inside the file, because that was just the survey picture. If you could go to the page where the drawings are, okay, and even look, you see up there, the balcony, keep going, there's 3 pictures that'll show the balcony. There's one more photograph.
That's the only 2 things.
No, and then you got the drawing. If you just go to the engineering drawing, it shows it right in there with all the measurements and no, that's the survey.
No, that's the drawing. That's exhibit H. That's the drawing. The survey is exhibit C. All the way at the top.
What is the application requesting?
The sun trellis is the only thing on the application.
No,
Well,
it
no,
was
no.
to use the 25 feet of my backyard, and that's what we asked for. I had no backyard.
Right there.
One
The
second.
variance request, the applicant requests a variance to permit a sun trellis to be located 7 feet, 3 inches from the legal property line.
I mean, the engineering drawings that are in the file, can you bring those up?
This is the entire file. This is everything scanned in.
Where's the engineering drawings?
Oh, the big ones?
Yeah, the engineering drawings are the big part of the file.
I'll have to double check. And I'll double check on the
Yes,
physical file.
they're in
I
there.
understand.
But this is the.
They are in there.
Okay, that's the survey pictures.
Well, even though you don't have the engineering drawings in the file, the engineering drawings are definitely part of the file. Okay, and in the engineering drawings, there's 10 full sheets of pages of one by one of how the beams are connected to the wall, how it's wrapped around the balcony, how the balcony is going to be built. It's all in there.
And the variance request?
Yes, yes, ma'am.
I'm gonna double check the paper to see.
Well,
if
it's an
there's
exhibit
engineering
attached, but it's not stated.
But in that drawing, we should have seen that the trellis doesn't go right up to the existing balcony and ask that question. Right?
I think that's up to the building inspector.
Well, I'm saying whose responsibility was it to catch that? And therefore avoid this kind of thing happening.
I don't see how we can.
The applicant asks for the variance, and it's up to the applicant to review the code and figure out based on their plans what they're revising or adding on to put that in the applicant. I can understand the concern that maybe staff should have caught that, but we go based on the application. And if they don't fill in all the things, just like on your previous case this morning, they recognized now they had to get 2 things to be a variance from the CCL and the side setback. It's the same thing here, and that's what's, the staff struggles with, because it's the applicant and their contractor's responsibility to come forward with what they need, because we don't want to be put in the position where we're advising them on what they need to do.
Because in fact, what they needed at the time was a variance for the sun trellis and a variance for the balcony.
Well, may I just say one last thing about that? That's not what we were told. What we were told was that we were encroaching upon the setback with the posts.
Yeah.
And that because the posts were permanent in the ground, people even said in here, we don't care about what's in the airspace, you don't even care about what's gonna come in off of the canal. So our balcony, which is sticking off the house 3 feet, has got no posts and nothing underneath it, it's just there. All they're doing is expanding a little bit to make it stronger.
But it's connected to the
They never said,
trellis.
we never knew
It's
this.
still up in the air. It's nothing on the ground.
We didn't know that was, because that was not what they told us that we had to do. What we had to do is we had to do a variance for the posts. That was the encroachment. We were not told about anything else. Otherwise, we would have totally did it.
Well,
And on top of it, this was done before we put up the sun trellis that he made us take down. So why didn't he bring that to our attention at that time?
well, as we said, it was not set forth in the application.
But we met, I paid $500 to meet with the town to know exactly what I needed to do.
And just for the record, I mean, there's something on the agenda to consider anything else besides what we'll consider today. So just keep that in mind. I mean, we can continue, you can ask us to continue to work with the applicant, which we can't. But there's nothing on the agenda, and there's really nothing, the board could do to make a decision at this time.
I understand that. Yes, I was going to say, it's unfortunate we can't help you today. I understand your frustration, and that's what we would do, is ask you to get together with the town and see if there's a way that they can help you facilitate either this new application or a way,
We have no problem to work with. These gentlemen have been great and excellent. This young lady has been phenomenal. Whenever we had to get together with the city before we met with you guys, we went over everything from A to Z. And like I said, we went over everything from A to Z. We went through the actual drawings and we looked at stuff like that. So we never knew that this was an issue. Now, anyway, let's just leave it at that. And so I guess what we got to do is work with the city. And if we don't have to do
Tracy?
another variance,
Yeah, I'll work with you to waive the fee for the new variance.
Okay,
Oh, that
thank
would
you.
every penny helps.
yeah, that's a nice,
Can we set up a meeting then, maybe before the end? I start my new job next Monday. I don't know what my new schedule is going to be like.
well, I'm sure you can work it out,
Yes,
but we wish you well.
Thank
And
you.
we're sorry that this,
thank you. You don't have any idea. Thank you.
yeah. Thank
Okay,
you.
nothing animosity. We just want to get it done with
No,
everybody.
we love seeing you here every meeting.
He gets a new outfit every time.
Thank you, guys.
All right, so we just call you. Thank you.
Is there any other business to come before this commission? Public comment? Anything you want to talk about? This is your chance.
I did ask Tracy if they could just look at some history on the chicky huts.
Right.
It would be good for us to know, but it's just going to come up again, I'm sure. I asked Tracy if they could put together some history on the chicky huts that have been.
We differentiate between a chicky hut and a tiki hut.
Yeah.
The chicky hut is actually built by, Native Americans. And that's
Why they approve some way.
Under Florida.
So that's a clever distinction.
Yeah.
Cheeky versus.
Cheeky versus tiki.
Yeah.
So I just want to mention something, and, staff can certainly research, what the other ones were and how they, existed. I just want to let everybody know that if we determine that someone has a cheeky hut and they didn't get the proper approvals, then you may see a community standards, a code enforcement case be started against them. So once we start looking into these things, oftentimes we find things were put up without the proper approvals, and to keep everybody on the same level playing field, we may now need to go, since we are aware that they don't have proper approvals, and seek enforcement action. And I don't know that that's the intent. I understand you understand.
I would bet that like 6273 North Ocean, they probably got approvals along the way, right? But
Possibly.
Yeah.
That's what.
Possibly,
So
possibly not.
it's kind of a double-edged sword when you ask staff to research things, because sometimes we find stuff, and sometimes it results in us asking to change the code. You know, because we found recently with sewage plants had 8-foot walls around them in several places around town, so we proceeded to change the code to increase the height. But other times, so we don't constantly compare variances to other properties, then what the town needs to do is go and pursue a community standards case against someone if they don't have any approvals.
So be careful what you ask for.
Yeah.
Right.
Absolutely.
All right, any other discussion?
Maybe we should just turn it to planning and zoning and say if a platform meets within the appropriate setbacks or
Yeah.
whatever,
The 5
then a cheeky hut would be.
subject to all the conditions that we just talked about.
Yeah, because I think any kind of survey that we ask for in terms of looking back is going to result in enforcement action.
Okay,
And we don't want to be that kind of a board where we're
right.
penalizing.
The thing is, we have ordinances. The ordinances were made to protect people on both sides of the people that are applying for the ordinance.
Mhm.
And we have to think, if everybody does it, what will be the effect when we become New York City pretty soon with built wall to wall? Just because I want is not a reason for a variance. And yes, it's convenient. Yeah, sometimes they want a structure to the side so they have a good view. They forget what happens to their neighbor. And I think we always have to consider.
You're right, we do have to consider the impact on others.
I'm the antagonist.
It's good to have you. We need your insight and your historical association on this committee.
Why, I don't know why we had the restaurant though, which was right in the middle of that good restaurant.
Bushes? That was next to me.
Well, yes,
Yeah,
but, well, you're something.
there would be Portofino. Was Bush's Restaurant.
We passed codes and we lived up to the codes. and Bush's had.
Now Betty wants to undo it and get Bush's back.
I'm all for it.
Ask her to put in an application. All right. Any other, Bruce, you want to say something?
Madam Chairman, I move that we adjourn.
Really?
All right,
I'll second that.
all right, and I'll pound on it.
Yeah.